There will be a court appearance where often they'll want the client there, and the date for trial will get confirmed. It's usually within days or a week or so before the actual date that the trial's set for. Now, there are reasons why it can get delayed, why if we're there on a Thursday and the trial's supposed to start on a Monday, it might not start on that Monday. It may start days or weeks or months later. I'm not going to go into all the procedures of that, but once we do get to start the trial, the first thing that happens is typically what are called motions in limine, and that's where your attorney, which would be me, if I'm representing you in Marin County, and the district attorney, the person prosecuting you, the person trying to convict you of a DUI and put you on a 3-year probation, we would be in front of a judge, sometimes in their chambers, sometimes in court, doing what are called motions in limine. And those are basically the ground rules for the trial. We're trying to keep out certain evidence or get certain evidence in and make sure that certain things that the prosecution shouldn't be allowed to say or do, or their witnesses shouldn't be allowed to say or do, are ruled on by the court before the trial starts. So sometimes that can take hours, sometimes it can take days, depending on the complexity of the case. Once we've got all that figured out, then what happens is a jury panel is brought in, and 60 or so people will be brought in who are on jury duty, and they will be asked a number of questions. I'm assuming most people have either had jury duty or seen what it's kind of like, and so the judge will ask questions, and then the attorneys will get to ask questions, which is called voir dire, questions of the jurors. And then we get to politely ask jurors to leave for different reasons. Each person gets a certain number of challenges. Each side, I should say, the defense and the prosecution, and eventually a jury is picked. After the jury's picked, then we typically have what are called opening statements. And the opening statements, the prosecutor goes first, and this is where what is going to be presented, what the evidence is going to show is given to the jury in sometimes just chronological order, sometimes in a story. There are many different ways to do this. Defense attorneys are different in the way that they do this. Actually, the defense is not even required to do an opening statement. We typically do. It's usually beneficial, but there have been cases where one is not given. Once the opening statements are presented to the jury, then witnesses start getting called. The prosecution puts on their case first, and so they will call in cops, forensic toxicologists, potentially the phlebotomist, person who drew blood if it's a blood case, any witnesses that they have, any type of expert witness they may need. And so they will bring in all those witnesses. Those witnesses will go through what's called a direct examination. Then the defense attorney gets to do what's called cross-examine them. And that is done, and then it can go back and forth, and you can have redirect and recross depending on how many more questions are needed to follow up after each attorney asks their questions of that witness. Once the prosecution has called all their witnesses, then if there are defense witnesses, which would typically be expert witnesses, a forensic toxicologist, or just witnesses to the scene, sometimes medical experts. There could be different types of, depending on the type of defense. If it's a GERD, gastric reflux type defense, or maybe medical doctors and reflux, someone who treated you for the reflux, toxicologists who can explain how that works with the machinery. Those types of experts will come in, and then sometimes the prosecution will recall a case after the defendant's case is over, witnesses are over. And sometimes the defense doesn't even call a witness. I've had cases where we've called no one because we felt the prosecution couldn't meet their burden and didn't need to bring in our own witnesses. The defendant testifying is always a decision to make, and it's something, some attorneys like to have their clients testify, others don't. Every case is different. Every attorney is different with that. So once we're done with all the witnesses, then the jury instructions are often read, and then summation or closing arguments are given, and the prosecutor gets to give theirs, and then the defense attorney gets to give theirs, and then the prosecutor gets to give another one, which is not fair, but it's a system that we're dealing with, and people who are jurors need to understand that this is what's going on, and this is, they get to basically, the prosecutor gets to clean up their case after all the holes have been presented by the defense attorney, all the reasonable doubt, then they get to try and close up that reasonable doubt in a final argument. In Marin County, for a DUI case, the prosecutors basically have a big book and a script, and they're pretty consistent in going through it. Their job is to get their witnesses, their cops and phlebotomists, and ask them about the procedures and what happened next, and the defense, your attorney's job is to show why the elements of the case, which are driving and either being impaired or at or over a .08 at the time of driving, why those elements cannot be met beyond a reasonable doubt. And typically, unless it's a no drive defense, most cases are not no drive defenses, we're fighting on the second element, which is either impairment or being at or over a .08, and the prosecution just has to be able to prove, or I should say, get a guilty verdict on either the impairment charge or the .08 charge. They don't have to prove both of those. They just have to prove one of those beyond a reasonable doubt to the jury. And if 12 people all say guilty, then you would get convicted of a DUI. On the other side, the defense is trying to get not guilty on both of the charges, and typically those are the two charges. There sometimes are other charges, the 23-152A impairment, 23-152B being at or over a .08. And what we're trying to do is get a unanimous 12 saying not guilty on both charges, or if we can't do that, hang the jury. And if there are less than 12 guilties on both charges, then it's a hung jury and you have not been convicted of a DUI, and the prosecutor will need to make a decision whether or not they are going to retry the case. In Marin County, over the years, the most times I've seen a DUI retried are 3 times. And in the end, it turned out to be a not guilty verdict. But DUI trials are expensive. It's hard as the defendant, as the client, going through them, having 12 people judge you, but it is your constitutional right and is something that needs to be taken very seriously. And if you felt okay to drive and you're real close to the limit and you got some good defenses and you want to go for it, by all means, go for it. Try the case, and have a lot of long talks with your attorney about that. It's your right, and it sure is nice to avoid having a DUI on your record. The other thing about Marin County and jury trials is that the penalty, typically a judge, unless you got on the stand as a defendant and the judge thought that you lied, typically they're not going to put you in jail or give you that much worse of a punishment as you would have gotten in the plea bargaining. Your attorney could not get the charge reduced. You're going to have most of the same requirements. It's just going to have costed you a lot of money and time and stress. There is always a risk of, on a typical first offense DUI, up to 6 months in jail. But in Marin County, on a first offense, where a client has not testified or defendant has not testified, I can't remember ever seeing that happen to someone going to jail for 6 months or anything like that. That's not typically going to happen. So it's a decision that needs to be made very informed, and having an experienced DUI lawyer will definitely help you make that decision. If you don't get a lawyer, or if you don't go to trial, don't even think about it or go over the pros and cons of doing it, and you just plead guilty, you will potentially wonder for many years whether or not you could have won that case at trial. So while most people don't end up choosing to go to jury trial, it's something at least to think about really hard and understand everything that's involved with it.